Welcome to Law by Simpsons. This class will be on misrepresentation. Now, misrepresentation, it's a false statement made by one party which induces another party to enter into a contract. When a party is entered into a contract because of misrepresentation, it can seek relief, such as rescission of the contract. Now, it's important to know that the misrepresentation being a false statement, that statement cannot be a term of the contract. Now, I'm going to go through the requirements of misrepresentation, and then we're going to together go through a scenario using Simpsons characters to make it a bit easier to understand. So the first requirement for misrepresentation, it's reliance on the statement. If the statement made that was false was not relied on by the aggravated party, the party seeking relief, then effectively no loss has been caused to them, and they would not have a cause of action in misrepresentation. The second requirement is that the misrepresentation was a statement of fact. So it wasn't a misrepresentation of his belief or her belief. It was a misrepresentation which gave the intention or put it in the other party's mind that what was being said was a statement of fact. Lastly, the representation must be positive. That's a U. Now, when we say the representation must be positive, we're not talking about it in the general context of positive and negative as in happy and sad, that generally you associate with emotions. But when we say that the representation must be positive, what we're saying is that it cannot be silence, effectively. It must be a positive word spoken, not silence. However, in some situations, silence is taken to be sufficient. So where a statement is technically true but gives a false impression, then that's a statement. That would be considered a positive statement that gives a false impression. Now, where we say that the statement must be positive, there are exceptions to this, and these exceptions arise when there's a duty of disclosure. Now, this duty of disclosure arises typically where generally in special or fiduciary relationships, they're called. Now, a fiduciary relationship will be addressed in another video. However, in summary, you become a fiduciary for someone else when you are expected to act in a way that puts their interests paramount, effectively. If you're a fiduciary for someone, you have a duty not to profit and not to have a conflict of interest with them. That's for another video, but effectively there may be a duty of disclosure in some special relationships. So, now let's go into a practical example. We'll actually go through two practical examples. One where there is a duty of disclosure and one where there isn't. Now, firstly, we're going to use Ned Flanders, Principal Skinner. Okay. Now let's say hypothetically, in the case that in the scenario where we're making, that Ned enters into a contract with Principal Skinner where Ned supplies Springfield Elementary School with recreational toy planes. I might have to choose the one thing I can't draw. There's the okay. Oh no. Recreational toy planes. In return, Principal Skinner pays. Now, assuming that all the elements of a binding contract are met, all pre-negotiation talks which induced Principal Skinner to enter into the contract, giving Ned Flanders money, if Ned was not honest or made a false statement to induce Principal Skinner to enter into the contract, then Principal Skinner could seek relief from the contract. So let's say the misrepresentation is that these cardboard planes, model planes, are the best quality. Never will break. Because Principal Skinner cares about his kids, he obviously would want his students to have good quality planes that don't break. So he enters into the contract. But a month later, half of the planes are already broken. Now, if it can be proven that the first element, being reliance, I shouldn't have rubbed him off, that Principal Skinner relied on these planes being the best quality to purchase them. Secondly, that the statement of fact, not Ned's beliefs. So Ned said that these are the best quality, never would break. That's not a statement of fact. That is a statement of fact. That's not just him saying, "Oh, I believe they're pretty good planes." No, he's saying that as a statement of fact. So that's satisfied. And thirdly, positive. So Principal's going to rely on them. It was a statement of fact, this misrepresentation, and it was a positive. It wasn't silence. Silence in this situation would be Principal Skinner asking Ned Flanders, are these the best quality planes that would never break? And Ned Flanders staying silent. So that wouldn't suffice to be a positive representation where Principal Skinner would assume or believe that Ned Flanders is saying yes, they are the best through his silence. That's not sufficient. Now, because there is no duty of disclosure, as there's no special fiduciary relationship, silence would not suffice. But in this case, Ned has actually told Principal Skinner that these are the best. So all the elements are satisfied. Therefore, it's most likely on the balance of probabilities that Principal Skinner would have a cause of action against Ned Flanders for breach of contract, where he could have the contract rescinded, damages paid. Now, while he could obtain rescission of the contract, that rescission is more of an old. It's wrong to say old. It was used much more in the past, but today, if the misrepresentation occurred in a business context, let's say Ned Flanders owned a business that sold paper planes. Then that transaction would be covered under Australian consumer law. And Principal Skinner would most likely argue that it was argued under misleading or deceptive conduct. Therefore, he would be compensated under the ACL, which offers more extensive damages. So that's an example where there's no duty of disclosure. So now we're going to draw an example where there is a duty of disclosure. Where there would be a duty of disclosure, I'm just trying to figure out what characters to use. We'll say father and son. Now, I wish I had doctor patient. Okay, we're just going to assume that Krusty is the doctor, and Bart is a patient. or Bart is a business. We're Mr. Burns. So Mr. Burns owns a hospital. Krusty is a medical supplier. This isn't exactly the doctor-patient fiduciary relationship I was thinking of, but there's even fiduciary relationships amongst business associates. But that will be, as I said before, a different video. But effectively, being business associates, there's a level of reliance and trust. Now, let's say Krusty is supplying Mr. Burns' hospital with first aid kits. Okay, that's my first aid kit. And in return, oops, wrong colour. In return, Mr. Burns pays money. Now, the three elements, we'll set them out here. So reliance, statement of fact, positive. So when you set out your essay, if you are in law school, you really want to set it out almost addressing the IBID method, which is issue, also the IRAC method, issue, rule, argument, conclusion for all of these. So the issue is, was there a reliance? Was there each of those? And just go through that method. So we'll sort of do that quite quickly here. So was there reliance? You could argue that Mr. Burns relies on Krusty to have these medical equipment, and if Krusty says that these medical equipments, these first aid kits are the best in the world, or the best money can buy, and Mr. Burns decides to choose Krusty, then there is a reliance on those statements due to the fact that he wants the best for his hospital. So that's satisfied. Statement of fact. It's clear that saying that these are the best in the world, this is the best money can buy, that's a statement of fact. And positive. Yes, it is positive. So, but now, let's say that Mr. Burns asks, so Mr. Burns, MB, are these the best? Are these good quality, let's say? And Krusty replies, ... silence. Because they're business associates, or let's say Krusty is in a position, is in a better position to know the facts than the other party. That's also an exception which brings forth the duty of disclosure. Let's say Krusty is in a position and he's concealing information where he's in a better position than Mr. Burns. Let's say Mr. Burns, although he owns a hospital, he doesn't have much knowledge on hospitals, but Krusty knows everything about hospitals. Therefore, he's in a better position and he's concealing information. So there is a duty of disclosure. That silence would actually suffice, even though it's not positive words. You're not actually saying anything. If there was no duty of disclosure, that would not suffice. Silence would not suffice. And that's what's important to note about when there's a duty of disclosure. Now, if you've undertaken subjects such as equity and trusts, and you are aware of what occurs in fiduciary relationships, then understanding when a duty of disclosure is or isn't enforced or evident is much easier. But then there's a lot of first-year law students who've only done intro to law and are just touching on contracts A, and you guys probably won't know that yet, but you don't have to stress about that. That'll probably be in your second or third year. So once again, if Krusty had a business selling these medical kits, then Mr. Burns would most likely sue under the ACL to get a larger degree of damages. So I hope that was informative, and I hope you enjoyed the video. I hope you guys enjoy studying, and I'll see you next video.